Good morning everybody. This is the second of my redundancy vlogs. Yesterday was all about starting the process. Today is about the three most common types of redundancy and a fourth which is often treated as redundancy but isn't, and also the three most common failings or lines of attack you receive in redundancy situations. So, without further ado, three types of redundancy. First, the employer ceases to carry on business for which the individual was employed. And this typically is where the work stream in which you are based ceases. You know, they're making radios and television sets and they decide they're not going to make television sets anymore. Anybody working on the television sets, well, they're redundant. Second type is where the employer ceases to carry out work at the place where you're employed, and that typically is where the unit or shop at which you are based shuts. And the fact that you may have a mobility clause in your contract permitting the employer to move you doesn't mean that you avoid redundancy when they shut your particular unit. The relevance of the mobility clause tends to come into play when they're talking about alternative employment to which they might reasonably move you and expect you to take up because of your mobility clause. And the third area is where requirement for work of a particular kind ceases or diminishes, and this is the usual headcount case where they take 7 machinists and decide they only want 4. The fourth area, which people treat as a redundancy but are mistaken to do so, is the classical reorganisation where there is no reduction in headcount. And in this latter case, that reorganisation is not a redundancy. There is no reduction in headcount, and it could be a complete restructure of the way the company does things, its shift patterns, etc., etc. And in those circumstances, potentially individuals can be dismissed if they refuse to work within the reorganised enterprise. They're dismissed, they get their notice pay, but they do not qualify for redundancy because they're not redundant. And that's called SOZA, by the way. Turning to the three most common failings or lines of attack in any redundancy case. I've been doing this game for a lot of years, and in my experience it comes into three basic categories. The first is the employer consults too late or inadequately, typically because the employer's thought about it, decided what he or she's going to do, and then simply does it without bothering to listen to what the people have to say. You need to begin consultation at the point in time where a proposal is being formulated, not when a decision has been reached. The second thing is where there is alternative work available and for whatever reason the employer decides not to offer it to the individual. Mistake. You should always discuss any alternative employment with anybody, and if more than one person wants to be considered for it, well, have a competition. Winner takes all. And the third common mistake centres around selection criteria and scoring. Typically, the selection criteria and scores are subjective, difficult to understand, and lend themselves to the argument that it's all a sham, and the reality is you're targeting me for some other reason. So that's it for now. More tomorrow, and in the meantime, stay safe, wash your hands.